What are some of the issues that result from the California Court of Appeal decision in Kaufman dealing with documents related to California legislative history? Recall that the Kaufman decision was a 3-2 appellate court decision that, among other things, set forth a listing of legislative history documents that are cognizable or not cognizable for purposes of determining legislative history and intent. The case is Kaufman and Broad Communities versus Performance Plastering in 2005. The site is 33 Cal Reporter 3rd at 362. And so the Third District Court of Appeal, based here in Sacramento, wrote an opinion on a motion for judicial notice of certain legislative history documents and set forth a litany of both cognizable and non-cognizable legislative documents. So there have been some concerns expressed with the Kaufman decision. One issue that's been raised by it is whether the opinion undermines the importance of seeking legislative intent by limiting information the court can take into account in making that determination. In other words, does reliance on a handful of legislative history documents limit consideration of the remainder of a bill file, so to speak? Should a court review the entire body of documents related to a bill's enactment? Does consideration of the entire set of documents better explain what problem was being addressed and how the legislation was developed, and therefore give greater insight as to what the legislature intended? The Kaufman decision specifically excludes some types of documents from consideration by a court, but in my mind, they may actually be relevant to determining what is proper legislative intent or what was intended by the legislature in some of these cases. In addition, does the Kaufman decision even contravene existing state statutes as enacted by the legislative branch of government? For example, the Code of Civil Procedure explicitly provides in the construction of a statute, the intention of the legislature is to be pursued if possible. In addition, the California Evidence Code provides that in taking judicial notice, any source of pertinent information may be consulted or used. Section 454B says exclusionary rules of evidence do not apply except Section 352 and the rules of privilege. These statutes may provide the basis for courts to consider all documents from legislative bill files and allow individual judges to determine their relative probative value. The fundamental concern expressed by critics of the Kaufman decision is that it's reliant upon the decision in California Teachers Association versus San Diego Community College District. There, the court determined that the legislative history documents must shed light on the collegial view of the legislature in order to be used. Based upon its reliance on this decision, the Kaufman court further restricted the general rule to limit documents to statements communicated again to the legislature as a whole, is the most important phrase there. But this position, I think, belies a misunderstanding about the legislative process and the knowledge of legislators when voting on bills. In concept, the idea that a document setting forth legislative history must be communicated to the legislature as a whole doesn't make much sense because it's based upon the assumption, I think incorrect, that those types of documents actually reflect the intent of the legislature. It also assumes that the entire assembly and the entire Senate has read a bill analysis, for example, and acknowledges that this document reflects their intent in voting for the bill. The other point is that litigation over statutory language needing an interpretation by the judicial branch is rarely reflected in some of these legislative documents. Instead, legal disputes over language could more likely be helped by statements made by the bill's author, or even its supporters or its opponents. Similarly, a litigation usually results over precise language of a statute and an ambiguity or a dispute over whether the language applies or doesn't apply to a particular set of facts. But this type of situation is almost never addressed in the documents supplied to the legislature as a whole. Instead, it'll be other documents generally not accepted as being of probative value or cognizable as legislative history under the Kaufman decision. And therefore, there's some question whether or not Kaufman should be updated to reflect the legislative process and some of the other documents that, in fact, do have great probative value in determining what is the intent of the California legislature in enacting a particular bill and the relevant statutory language.